Good afternoon and good morning, everyone. Thank you for joining us for this webinar, where we are going to start a discussion and present the new trademark revocation and invalidity proceedings, which are now available in Italy. I'm not going to say anything about that because the webinar is going to actually be hosted by two of our colleagues, and I will introduce them to you in a minute. Before that, I'm just going to point out to you that this webinar is going to be recorded, so the recording will be available after the webinar. And we think that it will be possible, we will have time for a Q&A session. And for this purpose, you can use the actual Q&A function, which is down in your screen. And I think that for the housekeeping, that's more or less everything. Before introducing the speakers and panelists, I just want to remark how important is this introduction of new proceedings that we have now in Italy. I've been dealing with IP and in particular trademark litigation for probably too many years. And it was pretty frequent that clients facing an invalid trademark registration asked for a quick and effective means to have it cancelled, thinking about something to be carried out before the patent office. And the answer, unfortunately, was always, well, it is possible to do this before the administrative authority in other jurisdictions, but in Italy, you actually have to go to court and with the related cost. Well, this answer, which convinced a number of clients not to do anything actually, and to deal with the fact that there are invalid trademarks, is not true anymore. We now have these long-awaited and hopefully effective new proceedings. We will have those means or this instrument introduced by two of our professionals and colleagues. First, we will have Roberto Valenti, partner of the IPT practice here in DLA Piper Milan, and then Ginevra Righini, who is the head of our filing and prosecution practice here in Milan again. And the final remarks will be directed and presented by Elena Varese, another partner of our practice. So without much ado, I will leave the floor to Roberto. Thank you.
Thank you, Gualtiero. Thank you very much, and thank you to all of you that agreed to participate to this webinar. I can certainly echo what Gualtiero said. We decided to organize a webinar in English, even if the addressees are mainly Italian, because there are a few English speakers that can be interested in this, that can be a game changer in a sense, because we will see in a minute the same remedies that we had in the past, but we will have this possibly powerful, cost-effective and timely option of the administrative action before the office. We can start with the first slide. And this is the outline of what it was possible to do before the end of December last year, and what is going to be, what it is possible to do now. And as you can see, I mean, before the Italian specialized court will have exactly the same competence that they had in the past. The novelty, the new thing is the possibility to bring trademark invalidity and revocation action before the office. And we can think it's a small thing. But again, when we will see the complexity and the length of Italian proceedings on invalidity and revocation, we may understand why this can be a game changer. We can go ahead. Next slide. Let's start with the trademark opposition proceedings. I mean, the first thing that is possible to do in case of a trademark which is to obtain the invalidity declaration or revocation of a trademark before obtaining the invalidity declaration or revocation of a trademark, it is possible to propose opposition proceedings. And for opposition proceedings, there is an exclusive competence of the Italian Trademark Office. As you will see, opposition proceedings in Italy are not different from opposition proceedings in many other countries. You have the possibility to oppose Italian trademarks or Italian designation of international trademarks. The opposition shall be filed within 3 months from the publication date in the bulletin. There is a cooling off period, which is very important because in many cases it is a very powerful mean to obtain a settlement agreement between to find an agreement between the party and to avoid lengthy and expensive litigation. If no settlement is reached, there is the possibility, the two parties have the possibility to defend, I mean, the applicant will defend the reasons, will explain why the application shall be granted, the opponent why this shall be refused. The decision can consist in the rejection in all or in part of the trademark application or in the refusal of the opposition. Very simple trademark procedure. The decision is can be appealed before the Board of Appeal. And the decision of the Board of Appeal is can be appealed for errores in procedendo and in judicando before the Supreme Court. Quite straightforward proceedings, but still we will see when we will discuss the case that we have prepared. It can be something that can take a few years. Next slide, please. Again, once the 3 months from publication on the bulletin of the application has expired, in order to obtain the invalidity of a trademark, you can only commence, you could only, before end of December last year, commence a civil action. The invalidity and revocation proceedings can be based on absolute grounds, lack of distinctness, genericity, deceptiveness, and so on, or, and this is much more frequent, the conflict with earlier trademark or registration in bad faith. The entitlement for invalidity and revocation proceeding actions, any interested party can commence invalidity or revocation action based on absolute grounds, while only the owner of the earlier rights can commence an invalidity action based on relative grounds. Next slide, please. And I apologize if I'm telling the obvious for the Italian audience, because many of you know exactly how the civil proceeding works, but this is for the benefit of how our foreign audience that may not know exactly how it works in Italy. Basically, civil proceedings and the invalidity and revocation proceedings before the specialized court are not different than civil proceedings commence with the serving a writ of summons on the defendant. The defendant will be called to appear at a certain hearing. There is a certain time that shall be granted in order to allow him to defend. The defendant will file a brief at least 20 days before the hearing. 20 days before the hearing, if the defendant wants to counterclaim or call third party in guarantee or raise procedural exceptions. And from that, it starts a number of hearings and exchange of defensive briefs that is concluded that after 2 to 3 years, the Italian proceedings is prevalently in writing, still prevalently in writings. I'm talking of the ordinary proceedings on the merits, the proceedings that you will start to obtain the declaration of nullity of a trademark, and the decision can be appealed once it is granted before the Court of Appeal, and the decision of the Court of Appeal can be further appealed on formal ground before the Supreme Court. Next slide, please. I was telling about complexity. I mean, I don't know if the complexity of the Italian proceedings is the Italian proceedings are more complex than in other countries. There is certainly a certain degree of complexity related to the fact that the normal rules for finding the venue where to commence the action apply for trademark infringement action. So if you commence an infringement action, you will commence it before the court where the infringer has its residence or domicile, or otherwise where the infringement takes place. And then specific rules apply for the case that the defendant doesn't have residence or domicile in Italy, or and other rules applies when neither the plaintiff nor the defendant have residence or domicile in Italy. The issue is that for nullity or revocation action, there is a specific rule with regard to the venue, because the domicile recorded in the registry will decide the venue where the action shall be commenced. And therefore, if you and this happens quite often, you commence an action requiring the ascertainment of infringement of the second mark and the nullity of the mark that has been filed in violation of your earlier mark. In this case, there can be an issue because you should file the infringement action in the venue where the defendant is domiciled or where the infringement takes place, which may not coincide with the venue where the trademark of the infringement is domiciled. And it is exactly, this creates an issue for the plaintiff that is going to be solved with this possibility that we will now have, that you will now have to commence nullity and revocation action before the office. Next slide, please. And this is exactly the case that that I'm going to briefly describe. for the sake of information, we have been involved in this case. We have represented the Epofashion. Epofashion is a Chinese company that commenced commercializing firstly in China, in Greater China, and then worldwide, women clothes under the trademark Mo & Co. and Mo & Co. edition. And when it came to Europe, Max Mara, which owns the trademark Max & Co., realized that there could be an infringement of their trademark rights, and therefore we can go to the next slides. Commenced. I mean, we will see all the remedies that we have briefly seen in the first part of the presentation. Commence an opposition against the Mo & Co. edition trademark that was filed and domiciled in Vicenza, so under the Court of Venice, by Epofashion. The opposition was rejected. Max Mara appealed the decision before the Board of Appeal, but the Board of Appeal rejected the appeal. Again, I say that the procedure before the opposition proceedings before the office is quite straightforward, but still, as you can see, not very fast. The office is trying to accelerate the pace of with which decisions are granted. In 2018, the Board of Appeal, so after the proceeding before the Board of Appeal took 1 year, the appeal was rejected, and Max Mara appealed to the Supreme Court for errores in procedendo and in judicando, and the proceedings are still pending. So after 9 years, the mark has been granted, but is subject to the final decision of the Supreme Court. In the meantime, and we can go to the next slide, Max Mara realized that products, women clothes, bearing the trademark Mo & Co. were sold on the internet, in not only in the Far East, but also in Europe. At that point, and this is exactly when I was saying the combination of infringement and nullity action, they commenced infringement action for the clothes that were sold over the internet with the trademark Mo & Co. and invalidity actions against the Mo & Co. edition mark that was under administrative procedure, opposition, and so on, and also the Mo & Co. marks that were granted the designation of international trademarks for Mo & Co. in class 25 that were granted, possibly Max Mara did not realize the existence of these marks when they were filed. The action was brought before the Court of Venice. Why? Because in Venice, the Mo & Co. edition mark that was the most annoying for them, because it was the latest, it was the one that was opposed, was domiciled in Venice. So they decided to commence the whole action in Venice. And Epofashion argued that Venice was, that Italy was not the right venue to litigate, because the products were not meant the products bearing the Mo & Co trademark were not meant to be sold in Italy. So Italy, there was no jurisdiction for the infringement action. And in any event, there was no competence. Venice was not the right place for the infringement action, because we were Chinese and Max Mara is from Turin. So Turin should be the place where to commence the action, and was also the competent court for the Mo & Co trademarks that were the designation of the international trademarks that were domiciled in Turin. And in 2019, so after a couple of years, or 3 years from commencement of the litigation, next slide, please. In 2019, the Court of Venice issued the first decision on preliminary issues and preliminary exceptions, and accepted, because, and this is, I must say, I mean, this is it was not that we were particularly good in presenting the case. This is a line that the courts in different places have followed with rare exception, to my knowledge, constantly. The nullity of a trademark shall be declared by the court where the trademark is domiciled. Therefore, Venice was not competent to decide with regard to the invalidity actions of the Italian designation of the Mo & Co international trademarks. And for the reason I explained before, Venice was not competent to decide on trademark infringement because Max Mara was domiciled in Turin, and there was no evidence of sale of products in Venice. That said, so Venice maintained the decision only for the Mo & Co edition mark that was domiciled within its jurisdiction, and the proceedings was suspended because, as I said before, we are still waiting. We are still waiting. We were waiting in 2019, and we are still waiting the decision of the Supreme Court. We can go ahead. And what happened at that point? Max Mara resumed the proceedings before the Court of Turin for the claims that were for which the Court of Venice had declared that it was not competent. And after a couple of years, so the proceedings lasted little more than 2 years, the Court of Turin issued the first instance decision and declared the invalidity of the epofation Italian designation for the Mo & Co trademarks because of the reputation of claimant marks, and because of both on, let's say, considering the mark confusingly similar, and considering that Max Mara deserved an extended protection consideration of the reputation acquired in Italy, and so granted an injunction, declared the infringement of Max Mara trademark rights, and granted an injunction for the use of Mo & Co trademarks in Italy. There is a deadline for appealing the decision that has not expired, and the parties are discussing possible settlement solution. But apart from the specific case, I mean, I think this case can be the perfect testimony of why the possibility of filing an application to the office that shall be decided within 2 years from the filing. This is the rule. Let's see if it will be respected. But the rule said that the nullity action before the office should be defined in 2 years from filing. Will ease a lot the issues that you have when you have an infringement case. Infringement case with a nullity action to be brought before courts. And therefore, I mean, if this remedy was available, let's say 10 years ago, I believe that the whole litigation would have lasted much less. The parts would have found an easier accommodation, an easier settlement much sooner. So, with no further say, and I will be available to take questions on this part, but now I think it is time to hear from Ginevra Righini, the head of our trademark filing and prosecution practice, the details of the nullity and revocation action before the office. Ginevra, to you.
Thank you. Thank you very much, Roberto. Well, I think that our listeners will agree that the overview that Roberto just now provided us of how court proceedings are in Italy when they concern infringement and invalidity actions, how they're complex and they can really last for a very long time. The case of the Ecofashion Max Mara case is really emblematic of the length that these proceedings can take. Therefore, I think that this really highlights how the introduction of this new alternative form of action before the office is really very much welcome and will allow trademark owners to possibly feel more comfortable to take action in Italy and not shy away and choose to take action in other countries where this proceedings before the office is available. Now, in the next slide that I will now show you, you'll see Italy and all countries of the European Union had to comply with a directive. The Directive 2015 on the harmonization of trademarks. Now, this directive provided that all member states should provide for an efficient and expeditious administrative procedure before their offices for revocation and or invalidity actions. And the deadline to commence such actions and to therefore put in place all the laws and regulations and administrative provisions was set on the 14th of January 2023. Now, this action, some countries took it earlier than us. For example, in Benelux, since 2019, we've had these actions, followed then shortly thereafter by France, and then by Germany. And then in Italy, we introduced these administrative procedure in 29th of December 2022. And then we were followed shortly thereafter by Spain, which right on the last day, on the 14th of January, introduced these measures. Now, I must say that when these measures were introduced, it brought me back to how I felt 11 years ago. Now, 11 years ago, when they introduced opposition proceedings before the office, it was such a change for my work. I remember that at the time, I organized a trip to the UK in order to meet as many colleagues, lawyers, or other IP practitioners to explain and highlight the advantages now of taking these opposition proceedings in Italy. And since then, in these 11 years, I have handled many opposition cases. And now I'm quite confident that there will be lots of administrative nullity actions and revocation actions, because definitely what Roberto showed is that in Italy, the length of these proceedings is really very long. And the length of these proceedings has even been highlighted by the Organization of Economic Cooperation Development, that has highlighted that one of the elements that puts Italy not in a very good standing is the length of these proceedings. So we really see these new administrative proceedings as I'd say a game changer. Maybe it's a bit of a strong word, but I really do think that it'll make brand owners more confident and to take these actions in Italy. Now, if we move to the next slide, I'll now highlight what is the subject matter of these actions. Now, it's very specific. We can take actions against either an Italian trademark registration or the Italian designation of an international trademark registration. So all trademarks are involved, be they individual trademarks, collective or certification marks. Just to remind you, in Italy, we can file a large number of different types of trademarks, traditional word, figurative marks, and then the more untraditional trademarks, color, position, 3D, hologram pattern, or factory sound. The variety is very interesting. For all other intellectual property rights, instead, the forum remains the same. Now that we've clarified what is the subject matter, in the next slide, we can see who can take action. Right. For revocation actions and invalidity based on absolute grounds, any interested party can take action. Instead, when you file an application for invalidity based on relative grounds, this can be done either by the holder of an earlier trademark that has validity in Italy, therefore the holder of an Italian trademark, an EU trademark, or the Italian or EU designation of an international mark. Likewise, also the authorized licensee of these earlier marks can also file an invalidity action. Another very important group of subjects entitled to file these actions are entities authorized under the relevant laws to exercise the rights arising from a PDO, Protected Designation of Origin, a PGI, a Protected Geographical Indication, a TSG, Traditional Specialty Guaranteed, a TTW, a traditional term for wine, or a PVD, which is a plant variety denomination. And last but not least, the owner of a trademark who did not grant either his agent or his representative authorization to file the trademark application. Now, in the next slide, now that we've understood who are the entities entitled, we'll see which are the grounds for revocation. Now, I started from the grounds for revocation for a specific reason. If we analyze the data of the number of actions that have been filed before the EU IPO, the data shows that the largest number of actions that are filed are the ones for revocation for non-use. According to data updated in September 2022, per year, the EU IPO receives between 560 and 610 applications for revocation. This is a considerable number, and I think that we'll be having significant numbers in Italy as well. Now, I was saying about revocation for non-action. So the holders of trademarks must be mindful to use their trademark. So once it's registered, after the 5 years from registration, they must ensure that their trademark is put to genuine use. Otherwise, that trademark becomes liable to a revocation action. Another ground for revocation is that the trademark has become generic, either because of acts of its proprietor or, more often, because of inactivity of its proprietor. And in this case, lawyers and IP trademark attorneys are there available to help trademark owners to take action to ensure that their trademark does not become generic and therefore avoid the risk of actions being taken against it to revoke it. Another and last ground for revocation is that the trademark has become misleading, either because with respect to the nature, the quality, or the provenance again because of the use made by its proprietor or the use made with the proprietor's consent. Now, in the next slide, we'll see which are the grounds instead for, next slide, please. The grounds instead for absolute grounds for invalidity. Please, thank you. So trademarks that have been registered despite, can we please go ahead? Thank you. Just go ahead, thanks. So we have the whole, still one more, click, thanks. Perfect. So here we have described all the absolute grounds for invalidity. So the mark is devoid of any distinctive character as from when it was filed. This means that when the Italian Trademark Office examined it, it did not, it considered it to be, to have distinctive character. At a later stage, once it's registered, you can file to ask for it to be declared invalid because it lacks actually that distinctive character. Because it has become, for example, a term that is at that time was already common in use, or it is a generic name of the goods and services at the time of filing. Or another ground is that it is contrary to the law, public policy, or principles of morality. And last, that it deceives the public, again, with respect to the geographical origin, the nature, or the quality of the products and services, or the type of trademark. Another possibility of absolute grounds for invalidity is that the mark is contrary to the regulations on PDOs, PGIs, TSGs, traditional terms for wines, or that it contains or reproduces in its essential element a previously registered plant variety denomination. Now, my feeling is that there was not on the part of the office a particular attention to these laws on the protection of PDOs and PGIs. So I do expect that there will be a number of cases where trademarks that contain the most relevant element of the PDO or PGI will possibly see an invalidity action filed against that registration. Now, in the next slide, we will see instead the relative grounds for invalidity. These are very similar, if not identical, to the grounds that can be used when we file an opposition. So we're possibly more familiar with these. Anyway, I will nonetheless explain them. We can take action on grounds, relative grounds, if the trademark has been registered despite it being identical to a trademark that is already registered and that is registered for identical products or services. So we have double identity. Or another case is that the mark is identical or similar to a trademark already registered for identical or similar trademarks. And that because of such similarity, this causes a likelihood of confusion. A third case is that the earlier mark has its reputation and that the use of that later mark would cause unfair advantage or be detrimental to the reputation or the distinctive character of the earlier mark. And last but not least, the mark is identical or similar to a trademark already well known under the terms of the 6 bis Paris Convention. Now, the last case is the case of the agent or representative of the proprietor who applied for the registration in his own name without the proprietor's consent and is unable to justify for which reason he or she took that action. Now, in this specific case, I'd like to highlight that this is the only case where the proprietor, instead of asking for the invalidity of that registration, can ask that the trademark registration be assigned to him. Now, if we move to the next slide, we'll see the keynotes of these proceedings. Now, Roberto, in his presentation, highlighted, please, you can move ahead with the clicks, thank you. You can go ahead. Highlighted the length of court proceedings. We've estimated of an average of 3, but we've seen in the case of the Max Mara app profession, 3 years, much more than 3 years. A decision instead before a court, the office will be rendered in 2 years from the filing date of the application, excluding, however, suspension periods. So this is something that is very important, and that is, I think, an element to consider when deciding which forum to choose. Another element that is important to note, when we file these actions, at the outset, we have to file everything, i.e. all our arguments, facts and evidence have to be submitted together with the application form. This is something different compared to opposition proceedings, where we, some of you might be aware, we file a notice of application, and then after 2 months from the end of the cooling off period, we file our arguments in support. Here in these actions, we don't have a deadline to file this action, but we do have a deadline in terms of immediately substantiating our requests. Now, something that characterizes these actions and that differentiates Italian proceedings compared to proceedings before the EU IPO is that in Italy, we have a cooling off period. Now, I think that this cooling off period will be essential in cases of invalidity and revocation actions, because we will have a 2-month period in which the parties can seek to find a settlement. Now, these 2 months can be extended multiple times for a maximum of a year. I do hope that they will be used. Oh gosh, my light. Anyway, that they will be used as much as in opposition cases, because in my experience, opposition proceedings often do not go ahead because during the cooling off period, we are able to find a settlement agreement. If you continue with the clicks, please. Okay, and please continue. So if during the cooling off period no agreement is found, then the owner of the mark will have a 60-day deadline to submit his arguments in reply and to request proof of use. If a proof of use is requested, then there'll be a second round of arguments. Now, the effects of a decision. The effects of a decision of the office are erga omnes, but from the time from when these effects will take place are different. In a revocation action, the effects are ex nunc. That means from the date on which we applied for the revocation, or if the applicant actually makes a request, from the earlier date when the revocation occurred. Instead, in an invalidity action, the mark will be deemed to not have had effect as from the outset. So that's the difference. Now, the decision of the office can be appealed before the Board of Appeal within a 60-day term from when the decision is issued. And then the decision of the Board of Appeal can in turn be appealed before the Supreme Court, again only for errores in procedendo or errores in judicando. Now, in the next slide, we will see the relationship between office actions and court proceedings. Now, an invalidity or revocation action is the application action will be the revocation or invalidity application is declared inadmissible if an application that relates to the same subject matter, same cause of action, and involves the same parties is pending or has been already adjudicated on the merits either by the office or by the court. And that decision has acquired the authority of a final decision. And then the other case, which is a rather unusual case, a case that is unlikely to occur, is that at the same time when the application is filed both before the court and before the office, and that application concerns, again, there's a triple identity between subject matter, cause of action, and parties. Again, an application to the court is inadmissible when an application or revocation action relating to the same subject matter and cause of action and involves the same parties is pending or has been adjudicated on its merits by the office. Now, in the last but one slide, next slide, we'll see when, if you continue to press, please, cases of suspension, and we're really at the end. No, please go back, thank you. I just briefly pinpoint something about the suspension. Now, suspension is obligatory if the application for invalidity or relied on a trademark or application that has not yet been granted. We have to wait for it to be granted, and then granted registration, and then the proceedings will go ahead. The same if the application relies on an international mark, we'll have to wait for the terms for refusal have lapsed, or for the filing of the opposition or the examination or the opposition have come to an end. Now, instead, a suspension is possible when an application relates to the same subject matter and cause of action, but involves different parties, is pending before the office or the court until a final decision is made. Now, in this case, the applicant has to ask for the proceedings to be resumed within 3 months from when the decision became final. And an application for revocation before the court can be suspended by the court when an application relating to the same subject and cause of action, but involves different parties, is pending before the office. And in this case, again, the party has to ask for the action to be resumed within the 3-month period. If we go to the next slide, we will see the key takeaways. Now, which route to be taken is really a case-by-case assessment. We have to consider all the various elements involved. For example, we have to consider that before the Trademark Office, we cannot contest that the application was filed in bad faith. We've definitely seen that this action is a fast route resolution of disputes. We have a 2-year deadline, not deadline, but the decision is rendered in 2 years from when the application was filed, versus much more lengthy proceedings before the court. This obviously has an immediate effect on costs. Moreover, costs of the official fees are much lower, €500 versus 1,036 before the court. And we won't have any hearings, and will be all filed electronically. And I think that the cooling off period will be a very effective way of finding resolutions of the dispute in a quick and timely manner. Thank you for your attention, and now we can pass to the Q&A session.
Thank you, Ginevra. Thank you. Actually, you responded to the last question that was posed, which is, why do we have a cooling off? What is the reason behind? It is just a postponement of the timing for a decision.
No, it's not a postponement. It's really an opportunity for the parties to seek a resolution of the dispute, an amicable solution. And it reflects what is possible in opposition proceedings. And it only lasts 2 months, so it's not a very long period of time.
And more in general, in Italy, there is a trend which is affirming also in the normal civil proceedings to increase the role of mediation or alternative dispute resolution. So I believe this is something that can help. Obviously, if the parties have to agree on requiring the cooling off. So if they find that there is no possibility to find a settlement, the cooling off can expire, and the case can be decided. There are other 2 questions. One is more regards the civil proceedings. I will read it as it is. In the case of civil action for counterfeit and invalidity action or cancellation action filed against the trademarks, which is the base of the infringement action, will the latter be suspended ex officio or upon request by the parties? In the latter, will the suspension be granted court discretion? This is I mean, the case is infringement action commenced again the trademark before the court A. Nullity action commenced, because if nullity is requested as a counterclaim, there is no issue. If nullity is requested in a different court, then there is the issue of establishing if the court of the infringement can decide incidental tantum the case while the invalidity action is pending. And to my knowledge, the majority of the case law is in this sense. So there is no suspension, no automatic suspension, and there are some cases where suspension has been granted, but I would say that this is the minority of the cases. The majority of the case, the court that has been requested to decide on infringement will decide, evaluating the validity incidental tantum. And we do have another. The last question is, I think, for you, Ginevra. Yes. Do the office employ additional examiner? How is the organic?
Yes, I can confirm that the office has employed additional examiners and that they have been trained. There's been a lot of effort on the part of the office to have a set of people. I'm not aware of the number of people who have been employed, but definitely I know that a considerable number have been employed and that they've been trained. Because I think the fact of this 2-year to give the decision will mean that the office will have to really speed up, and so we'll need a good number of examiners to handle all these cases.
Very good. I think we are approaching. I mean, there are some other reflections in the chat, but we can address queries also separately. We are approaching the end of the session, and we want to maintain some time for Elena Varese, who is the last speaker of the webinar, and let's say will conclude. We'll take the conclusion of today's session. So I would, unless Ginevra is any further, or Gualtiero, I will pass the stage to Elena for the conclusion.
Thanks so much, Roberto and Ginevra. Very, very clear. The main takeaways I'm getting from this seminar is that we now have a double path. The big question is whether I should go before the IPTO or still to court. Short answer to this is it depends, as any good lawyer would say. I could, however, think of few cases where it would be good to opt for the court or for the IPTO. For instance, we have a client that, let's say, carries out a sort of rolling monitoring of the registry. They want to promote several actions for lapse of no news. Then I would definitely go before the IPTO, for instance, because there's a quantity of actions, and perhaps those trademarks are, let's say, crowding the registry. So this could be done, I think, very well before the IPTO. On the other hand, as you correctly said, Ginevra, if the trademarks are filed in bad faith, I just can't go before court for asking revocation. But what if I'm sued in the merits for trademark infringement of a trademark which lacks distinctiveness? In that case, I have two options, of course. I could defend in court, and I could bring separately before the IPTO an invalidity action on absolute grounds. But I would really like my judge to know also on that part, also for, let's say, the sake of speed, and be, of course, influenced by these arguments. So I would bring that counterclaim before court. On the other hand, if I sue for trademark infringement where the defendant is domiciled, if I want to claim also invalidity, I should either go before the APTO or sue the defendant in the domicile indicated in the trademark registration. In that case, since I have not the advantage to go before court, I would rather opt for the APTO. There would be no impact on the court judging the case on infringement. So I would definitely go before the APTO. So these are my, let's say, preliminary reflections on your thoughts and remarks. Of course, it is a big chance for the APTO and all our system. And I think ultimately, if this is done well in the next years and the APTO keeps the deadline of the 2 years for the decision, I believe both the courts could reduce their workload and the APTO could be a valid venue to opt for these cases. Only the future will tell. Thanks everyone for joining in this seminar. And if you have further questions, our contacts are in the slides that will be circulated later on. Thanks so much. Have a good evening.
Thank you.
Thank you. Bye-bye.
Bye-bye.
Thank you, everyone. Bye. Bye-bye.
Bye-bye.